the matter proceeded on a plea of guilty. The reason for that is that myself as a lawyer, I've carefully analyzed all the evidence contained in the disclosures, or rather the docket, and I did thorough consultation with my client. And after all careful analysis, I realized that indeed, despite the fact that there were other circumstances that could have led to the abuse or to the violent behavior, indeed, he is guilty of the offense. My advice was then accepted by Jaco Swart, and he did indicate to me that after the incident and when they went their separate ways, after he came out from prison, they went their separate ways, he also realized that despite the fact that he was deeply provoked, what he did was unacceptable and therefore unlawful. Myself, as a person and professional, I do not condone violence against women and children or any other person or property, because I believe that we need peaceful means to resolve differences. Despite the fact that it's unlawful, I believe that we need peaceful means to resolve differences if we have differences. Again, the Constitution of the Republic of South Africa gives a right to every accused person to a legal representative. Now, as a professional lawyer, once I accept the mandate to represent someone, I must do so diligently, expeditiously, and never give unlawful advice. In other words, if I see that my client is guilty, I must advise him correctly and lawfully so, because of our ethical codes of conduct, and also because of my personal belief system. Hence, I accepted the mandate and did so diligently. I do not condone what my client did. And I didn't represent him because I like him or I like what he did. I represented him because I'm constitutionally mandated to do so. So it should be clear to the public out there that us as attorneys or defense counsels, we are not doing anything untoward to the court. Rather, we ensure that justice is done and must be seen to be done.
May I ask you, you referred to he was in prison. Was he arrested for this assault?
First, when I met him, he was arrested for fraud case opened against him by his father-in-law. That fraud case I dealt with from bail until a stage wherein, after receiving all the disclosures, or rather the evidence, I analyzed it carefully, and then I found that really there is some loopholes here, of which I did what we call formal representations to the senior public prosecutor and to ask certain questions to the complainant. To date, those questions are not answered. What we have is that the prosecutor then decided that they cannot continue with the matter until they get the response from certain questions that we raised on those representations. Therefore, the matter was withdrawn. But on the date of withdrawal of that, fraud case, then my client was served with summons for the assault case against his wife. So I continued until at a certain stage it was placed for plea and trial. Then the state could not consult with their client. They couldn't make up their decisions for several times. I think on the third time, I rightfully objected to further postponement in terms of Section 342, capital letter A of the Criminal Procedure Act, which gives the right to the accused, if the matter is unreasonably delayed, he has a right for the matter to be struck off. And then the magistrate who presided over the application upheld our application and then struck off the matter. The matter was then reinstated. When it was reinstated, it went back to the district court. On the date wherein we were supposed to proceed with it, that was in February this year, then I met AfriForum and the team. They said to me, we are the watching brief on this matter, and therefore the matter is triable in the regional court. I did question why, because it is justiciable in the district court. Cases of this nature are justiciable in the district court, unless if the charge is attempted murder, and then the magistrate or the person who presides over the matter decide that I cannot find you guilty on an attempted murder charge, rather I find you guilty on an assault, grievous bodily harm. So that was not the case. In our case, the matter was sent straight to regional court as a matter of first instance. It was assault GBH was a first count, not the attempted murder case. I did raise some objections, but then I felt like it won't be for any use. Let me rather continue. We will just tender the plea anyway in that court, because anyway, my client is guilty. Meaning, even if they took it to the High Court, we were still going to tender a plea of guilty, because my client understands that. So it came back on the 7th. On the 7th, I did inform the state and the watching brief, that is AfriForum, that we are going to tender a plea of guilty. And they said to me, that is a good advice. I said, it's not just an advice, it's a reality. My client is guilty. The facts are out there. Then we went inside court, we pleaded guilty. Now, when you plead guilty, the court would like to know, why did you do this? And I guess the public also will want to know, why did my client committed such an aggressive or violent offense? I stated in passing that my client was deeply provoked by the following. He discovered that his wife was having an extramarital affair with his prayer partner, and that I put it on record in court. Secondly, he discovered that she was stealing money from him, from his business. Then when he tried to confront her for these issues, an argument ensued between them. And then it turned violent. So the violence didn't just start from nowhere. It's coming from the arguments that they were having, the fraud and theft issue, and the extramarital affair issue. And then the plea of guilty was accepted by the NPA. We did indicate also how he assaulted him, where the kicking, the punching, and everything is there on our plea of guilty. So we proceeded to present that plea, and the presiding officer also accepted the plea and convicted my client on that plea statement. We did what we call mitigation factors before sentence. In our mitigation, we did indicate the provocation, but we never went into detail because I had proof with me of theft of money. I had proof of fraud with me, but my intention was to assist my client. Even the extramarital affair, I do have proof with me. My intention was to assist my client to tender a plea of guilty, which I believe is the right thing and lawful thing to do. Not to assassinate the character of the victim. That was never my intention. That is why some of those things I could not go into detail, because my client's instruction was, look, I committed this offense in front of my children, which I'm so sorry. I'm very much remorseful that our children had to see us fighting. But on the same breath, I don't want you to state everything that was happening, because then it will destroy more my children than assist me. If I have to go to jail, let it be. That was his instruction. Hence, my decision not to present all evidence, because if you are pleading guilty, then it's not your responsibility to assassinate the character of the victim.
These allegations were also made by her. So it's him saying that about her and she's saying that about him. And it appears that this was not an isolated incident that happened between the two of them, that there's a history also with other people, these cases that have been filed. Doesn't that change the situation?
All cases should be looked at on merits. So it will be difficult for me to answer for previous cases that my client faced, because I was not the legal practitioner at that stage. And I have no any instruction. I haven't consulted with him on that. What I got to discover was that most of the charges were withdrawn. So, and when I checked with him, they were withdrawn on merits. So I wouldn't dwell much on that. I just want to continue to indicate what else we raised on our mitigation. We did also indicate to court that the accused, ever since he separated with his wife, he has been undergoing counseling with different organizations or rather persons. Lastly, the last counselors that he's undergoing is with a psychologist and a psychiatrist, wherein he's also on medication. I'm not gonna disclose the type of condition he's suffering, but I would rather say their lifestyle had severe psychological effect on both of them. And also, before I forgot, both of them were on drugs. They were abusing drugs. So in most instances, they were not of a sober mind.
But do you think, sorry, no, carry on.
So I don't think people with that kind of lifestyle will be, I don't want to use the word normal, but I believe they will be limited somewhere, somehow, when it comes to resolving dispute.
Do you think, though, that he received an appropriate sentence? Because his wife says she's scared of him, and it scares her that he's not in prison. And she claims that he's been doing this for the past 10 years.
I'll tell you in our own language. I believe that the sentence imposed on my client is justifiable under the circumstance, because the purpose of sentence is not to condemn the accused. The affectors, you have to consider the interests of the community, the nature of the offense, the rehabilitation purpose to the offender. So now, I've said already, my client is currently undergoing psychological counseling as well as psychiatric counseling. So that sentence imposed on him under the circumstance is justifiable. And I want to put it clear that the sentence is as follows: 3 years direct imprisonment, or a fine of 20,000 rand. That means if he doesn't have money, he has to go to prison for 3 years. A further 3 years, which was wholly suspended for 5 years. He never had the money. We had to make an application to ask for a deferred fine so that he can pay at least 5,000 rand and get out of prison. I must say this as well. He has the responsibility to maintain his children. He has employees. He has loans, or rather debts, that he had to pay. So if you send this person to prison, you are not only punishing him, but there are other people that will be affected by that. But we can argue and say there is a prison term, so he had to buy himself out of going to prison. That's how it should be understood.
Do you think your client is in any way, you know, you're saying he's getting psychological treatment and help, but there's apparently another case that was opened days before he was sentenced. Do you think he's a threat at the moment to his wife or to society?
I think, with all honesty, us as the society, we are condemning him he's not a threat to anyone. The way the things happened and the circulation of the footage of him assaulting his wife sensationalized the society somehow, in that they now perceive him as a danger to society. But I can tell you, on a daily basis, my client is receiving threats that he will be assaulted, he will be killed, this and that will be done on him. And he's in hiding as we speak. He cannot come to public because he's afraid of his life. He is not gonna go any way near his wife. He's not gonna go anywhere near his wife because there are underlying issues which I do not wish to present. I'll allow the wheel of justice to roll over and expose certain things, because there's a lot that was going on. As much as the victim was victimized or was abused, there's a lot that if I were to show, I have affidavits, there are case numbers that were opened against her by him and again by his client. All the dockets went missing. I have case numbers with me here. I have affidavits drafted by friends, their friends, who are not condoning what happened between them, but who are saying, on the same breath, you are all wrong. But then I say, what my client did is unlawful and cannot be condoned.
Do you really think that the right message is coming out at the moment? If you think that South Africa is a country with such a high rate of domestic violence and gender-based violence, how can this case be used to make people aware that, women should be protected?
I have a problem there, Arisa. I have a serious challenge. I am a defense attorney most of the time, and I deal with domestic violence cases. Shockingly, the victims, they flood the court, look for prosecutors or control prosecutors or senior public prosecutors to say, I want to withdraw a case against my husband. When they failed, they come and approach us, defense attorney. I want you to assist me to get my husband out. And then when you tell them, it cannot be, this man assaulted you severely, it cannot be, they fight. So we are having a serious challenge. So I'm saying domestic violence has, in my opinion, several factors. It's not just what the criminal justice system is doing. There are socio-economic issues involved in these matters. So I think we need to debate more on how best can we cut the taproot of domestic violence. Prevention is better. The criminal justice system is at the remedy stage, at a later stage, but there are underlying issues that needs to be dealt with. And I think if once we realize that as a society, we will be able to curb this social ill.
Okay, I've got one more question two. The one is, what do you say to these other attorneys and legal experts who say it's possible that you advised your client to plead guilty because you knew it would mean a more lenient sentence? What is your response to that?
I'm a legal practitioner, they are legal practitioners. I conduct my case the way I deem fit and necessary. So if they say to me, I pleaded guilty because I would ask for a lenient sentence, that's their perception. But I'm telling you, personally as well as professional, my client committed an offense. There was no way I was not going to plead guilty. I advised him to plead guilty, irrespective of whether the sentence will be lenient or harsh. And I must say to you, my client did receive some harsh treatment, I must say. The jurisdiction of the offense is with the district court, not the regional court. My client was tried in a regional court. That's one. Two, at the district court, I've seen so many cases of domestic violence. People go with only wholly suspended sentence. They don't get 2 sentences like what my client got. However, we accept the sentence, and I'm saying it's justifiable.
I've got a last question. In the light of a public outcry, how did you representing Jaco Swart affect your practice? You as an attorney, has there been a backlash against you personally?
I can't say I've received that backlash. The only thing is that I feel that from the moment the story was published, it was a bit unfair because the first publications were done without asking for our input. We are only being engaged now. And when we are being engaged now, the damage has already been done. My client has received threatening messages already. And then the other thing, there is a video and photos out there of her engaging in some immoral activities. Now, my client and myself, I received a letter of demand to say, you must stop continuing distributing the footage, which I denied. I said, I never did. And from the first place, when those photos were being taken, neither myself nor my client were there in that room. And it's better if the public or you ask the victim to say who took these photos and then who filmed her and what happened thereafter, the filming and the photo shooting. Because those are the people that I believe distributed those things. And then I checked with my client to say, are you distributing anything? He said, no, I'm not. It's just that there are people who sent him using anonymous numbers, the footages and the photos. You know, I must say, as much as there are people who has shown that they hate my client, if they find him, they're gonna assault him, they're gonna kill him. There are also people who are sympathizing with him. And those are the people who sent him all these other evidences. And then we said, look, we pleaded guilty because we are guilty of the offense of assault. And we do not wish to go back. We just wish to proceed with rehabilitation programs and serve the sentence until it's finished.